Hello and welcome to this session in which we will discuss terms related to contract law. These terms are related somehow to contract resolution or defense used to discharge an obligation. So you need to be familiar with those terms. Now at this point, I'm assuming you are familiar with the elements of a contract, which is offer and acceptance, an exchange of value, an exchange of consideration, and no defense. Now in this session, we're going to learn about some ways that one party could have a defense in a contract. Well, the terms are accord and satisfaction in substituted contract, novation, condition in a contract, prevention of performance, parol, evidence rule. Those are the terms that we need to discuss, and you need to be familiar with them if you are studying for your CPA exam. Let's go ahead and get started. Before we proceed any further, I have a public announcement about my company, FarhatLectures.com.
Farhat Accounting Lectures is a supplemental educational tool that's going to help you with your CPA exam preparation as well as your accounting courses. My CPA material is aligned with your CPA review course such as Becker, Roger, Wiley, Gleam, Miles. My accounting courses are aligned with your accounting courses broken down by chapter and topics. My resources consist of lectures, multiple choice questions, true-false questions, as well as exercises. Go ahead, start your free trial today.
Starting with accord and satisfaction and substituted contract. Starting with those terms because they are a little bit related to each other. They are legal terms, legal concept, and they are used in the resolution of disputes in a contract or changes in contract terms. We'll start with accord and satisfaction. How does that work? This involves a two-step process. What happens is this. We are going to reach an accord. What's an accord? An agreement to substitute the old performance with a new performance. So first what we do, we come up to a new agreement because we have a performance in the contract. We have to complete this step, painting the home, mowing the lawn, whatever that performance happens to be. We're going to reach an accord, an agreement to substitute a different performance than the originally contracted for. And what we're going to do, the second is satisfaction. So it's an agreement and satisfaction. And satisfaction is the actual performance of this agreement. So the original duty in the original contract would remain in effect until the second step, until the satisfaction occurs under the accord and the satisfaction. So notice the original duty remains in place until the new agreement is fulfilled. Let's look at an example to illustrate this concept. Let's assume Jessica agrees to sell her vintage piano to Michael for $1,000. We call this the original contract. And after some discussion, Jessica and Michael decided to modify their agreement. Well, instead of selling this piano here, well, Jessica offers her antique violin to Michael for $300. Notice we change the performance now. This new agreement, this called the accord, which is a mutual agreement between the two parties, Jessica and Michael, to change the terms of the original contract. The satisfaction is to do what? Is when Michael actually pays and Jessica delivers the violin to him. At this point, the original contract, the sale of the piano, is considered settled and discharged. Basically, this is when you satisfy the original agreement by executing the, in quote, the accord and satisfaction, the new agreement. The sale of the violin is fulfilled. So in this example, if you notice, the original obligation, the piano sale, is replaced with a new obligation, but the fulfillment of the new obligation constitutes the satisfaction of the piano sale, which is the original contract. Let's now discuss substituted contract. Similar to an accord and satisfaction with a key difference. What's the key difference here? The original contract duties are immediately discharged. So the original contract is basically when we do a substituted contract, we X them out upon forming a new agreement rather upon the performance of the new contract. Example, Sarah hires Kevin to paint her house for $1,000. Original agreement. Before Kevin starts, they agree that Kevin instead install new windows for Sarah, valued at $1,200, and she'll pay nothing more. That's the new contract. Simply put, the original, if we substitute, the original contract is gone. As soon as the new agreement is made, no longer Sarah no longer has to pay $1,000 for house painting, and Kevin's obligation shifted to a new installation. Similar, but in a substituted contract, basically it's a new contract. We substitute this new contract with the old one, so the old one is gone. Let's talk about novation. Novation is from the word new, novation. Novation is a legal concept that involved replacing one of the parties in an existing contract with a new party, basically creating a new contract. For novation to occur, all original parties involved in the contract must agree to this change and release of the original party from their obligation. So we all have to be on the same page. Usually we have two parties, and we have now the third party that's replacing one of the parties. Let's take a look at an example. Linda has a contract with graphic design company Blue Design to create a website for her business. Well, halfway through the project, Blue Design is bought by another company called Green Graphics. Linda, Blue Design, and Green Graphics all agree that Green Graphics will take over the contract and complete the website for Linda. Okay, this agreement is innovation. How? Blue Design is released from its obligation to Linda, and Green Graphics steps in to fulfill the contract, and we are all on the same page. In contrast, if we have a simple release or an agreement to discharge one party without replacing them with innovation, replacing them in innovation. For example, if Linda and Blue Design has agreed to just basically terminate the contract without involving Green Graphics, this would have been a simple release. Such an agreement might require new consideration, of course, something of value exchange, or prove detrimental reliance, one party making the decision based on the promise of another to be enforceable. What you have to do is you have to have some sort of an exchange when you change the contract. Conditions. What are conditions? Conditions in a contract are specific event or situation that can affect the party's obligation to perform their duties. Condition can be based on when they occur or how they influence the contractual obligation. We could have what's called express condition. This is a specific condition, explicitly stated, it's express, that must be fulfilled for the performance or the continuation of the contract. For example, I will pay you $500 if you paint my house by the end of the month. That's the condition, express condition. You perform. Basically, this is a unilateral contract. I will pay you if you perform, so you have to perform. Here, painting the house by a specified date is an express condition for the payment. We could have conditioned precedent, before. This is a condition that must be met before a party's obligation in the contract becomes due. An example, you must obtain a certification in web development before I hire you to develop my website. Well, what does that mean? You get your certification first, I will hire you. In this case, obtaining the certification is a condition precedent to the hiring. This is condition precedent. More about conditions. Conditions concurrent, and this is one of the most common one that you experience every day without knowing. These are conditions that must occur simultaneously for parties to fulfill their contractual obligation. For example, when you walk into a store, a convenience store, a supermarket, Walmart, Kmart, whatever you go to, you exchange money with product. I will give you the car keys when you hand me the payment of $10,000. The exchange of the car keys and the payment are condition concurrent. They happen at the same time. It's like when you buy something from the store. Condition subsequent. Subsequent is after. This is the condition that, if it occurs, will terminate an existing obligation under the contract. Example, I will continue to lease this equipment to you at a discontinued rate until your business earns more than $1 million in a financial year. It's subsequent. Condition is subsequent, later. Subsequent is later. Here, the business earning $1 million is a condition subsequent, which upon occurrence end the lease agreement, that this discounted lease agreement. I'm going to have to charge you more. Prevention of performance. Prevention of performance when someone is hindering, stopping you from performing your work. If one party hinders or prevents the other one from fulfilling their contractual obligation, this is considered a material breach of the contract. And as a result, this could be used as a defense in performing. It's like, I did not perform because I could not. I can no longer fulfill my obligation of the contract. For example, Elise hires Ben to paint her store. Great. After signing the contract, Elise changes the locks and does not give Ben access to the store. Well, how is he going to paint the store? Elise's action considered preventing Ben from painting the store, and this is a material breach of the contract. So Ben is no longer obligated to paint the store and can seek legal remedies, if any. Let's talk about the parole evidence rule. Parole is from the word speak, talk. This rule applies to fully integrated written contract. The assumption is this: the written contract includes all what's necessary for the contract to be a standalone contract. So it's all in the contract. Those intended to contain all the terms of the agreement. So what's the parole evidence? The parole evidence prohibits introducing oral or written statement made before or at the time the contract to alter, contradict, or add to the terms of the written contract. So what we're saying is this: when we go to the judge, we're going to say, okay, we're going to use the parole evidence rule. We're only going to be looking at the contract itself. We cannot add any statement made before the contract was written or during, because this is the contract should express everything that we needed to express. The judgment should be based on that. Now, any modification made after the contract can be introduced. Example: Sarah agrees to buy a laptop from a store. The salesperson verbally promises a free laptop bag, but it was not included in a written contract. Later, when Sarah asks for the bag, the store refuses. Well, no. If they go to court and under the parole evidence rule, Sarah cannot use the salesperson verbal promise in a court to claim the laptop bag. It was not part of the written contract. If they promise you something, put it in writing, put it in the contract to be protected. However, bear in mind that evidence unrelated to altering the contract terms, like proving Sarah was a minor at the time of the agreement, that can be admitted, as well as other factors. If there's any fraud, duress, mistakes, you are allowed to introduce those, but not any communication that alter or change what is in the contract itself. Let's take a look at this multiple choice questions from Farhat lectures. What is the key characteristic of novation in contract law? Remember, novation comes from the word new, novation. What is novation? Do you need to know this? Absolutely. Is it the replacement of an existing party with a new party in a contract? This sounds like novation, but let's wait. B, the continuation of the original contract without any changes. No, that's not novation. Basically, novation involved changing parties, not continuation without any changes, so that's out. C, the unilateral decision to alter the contract terms. Well, novation requires consent of all parties. So when you say the unilateral, not at all. When you have a novation, all people involved in the contract will have to be involved. So unilateral decision, no. Either to alter the contract, to bring in a new person, it's not unilateral, okay? The termination of a contract without any replacement. On the contrary, novation is the replacement of an existing party in the contract. D is out. What should you do now? You want to go to Farhat lectures, look at additional MCQs. That's going to help you, whether you're studying for your CPA exam, taking a business law course. Invest in yourself, invest in your career. Take your education seriously. Farhat lectures is here to help. Good luck. Study hard and, of course, stay safe.